what we did 2 days ago with both sections was talk about this case in re Petition of Bruce Germain, which I guess I'll write it down. In re Petition, probably capitalized, but we'll go P, of Bruce Germain. And that's a Second Circuit decision from 2015. And case is 10 years old, but it still very accurately and thoroughly explains the law relating to Admiralty Tort jurisdiction, whether a court can hear a case depending on essentially three factors, which we're going to go into. And the opinion written by Judge Robert Katzman of the Second Circuit, now deceased, is like an exegesis on the law. It tells you how we got here, all the Supreme Court cases that got us here. It lays out the facts of the case. It describes the procedural history. You know, there was a state court personal injury case, and it was removed to federal court, and at the same time, the same lawyer also started a petition for limitation of liability. And the case is great because it shows you, if you read it carefully, that sometimes a petition for limitation of liability is the linchpin, the thing that gets litigants into federal court, and then the federal court does a lot with that. The other one that we discussed that began as a limitation case was the collision case, the Otal Investments, where the Kariba was held to be at fault. That began as a limitation action in federal court in the Southern District of New York. This one began as a limitation action in federal court in the Northern District of New York. Why does it have to be in federal court? Well, this is the thing I want to talk about at the outset here. Limitation of liability is something that only federal courts can hear. State courts are not considered competent to administer limitation of liability actions. It's exclusively federal maritime jurisdiction. And that statute, which was enacted in 1851, is used quite a lot. In order to use it, you have to be in federal court. But the catch is, just because you want to be in federal court and you want to do limitation doesn't mean you get to be in federal court. That's a whole separate inquiry. Because to be in federal court, you need federal subject matter jurisdiction, and that is a whole separate question than the limitation question. The Limitation Act says you've got to do it in federal court, and you can get this benefit from the statute, but there's nothing in any statute anywhere that tells you when you are or not allowed to be in federal court. That's a whole series of cases that the judges, ultimately the Supreme Court, have weighed in on, and they say basically yes or no whether you get to be in federal court on Admiralty Tort jurisdiction. When I say tort, a little refresher, there's basically two broad areas of lawsuits, tort and contract. I mean, criminal is a whole other matter. That's the state prosecuting somebody. But in civil matters, you're either suing somebody because they breached the contract, or you're suing somebody because they breached the duty they have to the public, and they were negligent or they did something wrong, and that's the tort. So in limitation cases, it's always a matter of whether or not the federal court can get in, has subject matter jurisdiction. Let me backtrack. It's a question of whether the federal court has subject matter jurisdiction based on Admiralty Tort jurisdiction. You're going to have to review, to really understand this, the videos from modules 1 and 2. But the bottom line is that federal courts have limited subject matter jurisdiction. You can't go in on any matter that you want. You have to have a basis for the federal court to hear it. That's called subject matter jurisdiction. For example, if I wanted to sue in federal court in New York for a divorce, I would be almost laughed out. I mean, there would be no way that the federal court would have jurisdiction over a matrimonial matter. It's just not part of their subject matter jurisdiction. So what about this limitation of liability thing? Well, if you are trying to sue and bring a petition, that's the petition, a petition for limitation of liability in federal court, which is the only place you can bring it, you still have to show that you have a right to be in federal court on the basis of the subject matter of the dispute. Now you would think, well, gee, if it's a matter of a ship and you know, ship hitting a bridge, and you know, big deal like we've talked about in other stuff, you know, like Sunshine Skyway Bridge and big tanker or whatever. Sure, that would be federal subject matter jurisdiction, almost a given, because it's a big commercial vessel in commerce on navigable waters, etc. But what has happened in the last several decades is that the Limitation Act has been used by lawyers who, they have a case where one person was injured, but it's big money injury, and that's the case here. You know, this guy was rendered a quadriplegic. And so the defense says, well, we're going to bring a petition for limitation of liability in federal court, and then if the plaintiff gets multi-million dollars, they can only recover the value of the vessel, which, you know, in this case it was a recreational vessel. I don't know what it was worth, but I'm sure it was well under 100,000. It may have been like 50,000, it may have been 20,000, but it wasn't worth anything near the amount of money that the plaintiff could make. So Jim Mercanti, the lawyer in this case, who filed a petition for limitation of liability, had a great idea, and he does that routinely. The Limitation Act is used for that sort of relief in federal court, where some claimant who has major injuries, and it's the only claimant, but it relates to an operation of a vessel usually, and they go in and they try to limit the liabilities, because then, you know, instead of the defendant being on the hook for multi-millions, they might be on the hook for tens of thousands, you know, whatever the value is of the vessel. And particularly in cases where it's a small recreational vessel, we're talking about vessels that don't have a lot of value. So anyway, what happened in this case? We went over it on Monday, we had some interactive discussion, but the bottom line is, before the court could decide whether to even entertain the limitation petition, the court had to decide whether it had jurisdiction over the action itself. And now, we're going to look straight at the law. And we're actually going to eliminate, out of 3 possible tests, all of which have to be satisfied, we're really only going to focus on one. So, in order to, you know, this is not working. Let me try another eraser. Yeah. All right. So what happened in this case? In this case, in Petition of Bruce Germain, you had a navigable waterway, Lake Oneida, and here you are on the shallow part, and it gets deeper as you go over here, and it's still the same waterway, it's Lake Oneida, and here's a recreational vessel, and they're sitting at anchor, and somebody, let's say there's 5 feet of water here. Somebody jumps from up here, dives in. Well, we won't put them too close to the edge. I'll let them dive in this way. Bottom line, this passenger on a recreational boat dives in the water from way up here, shallow water, and of course the speed that he built up diving was much too high for a sudden impact at the bottom of the waterway. He didn't realize he was diving into such shallow water. He was probably somewhat inebriated and 20-something, immortal as most 20-somethings are, so therefore he didn't think about his possible death. And he got sort of lucky, he didn't die, but he became a quadriplegic because his head hit the bottom and, you know, severed his spinal cord. And bottom line is, he sued the owner of the vessel, Bruce Germain, in state court, and then Jim Mercanti, the lawyer who represented Germain, removed that to federal court, which is a procedure we're not really going to talk about, but he also, more importantly, filed a petition for limitation of liability at the same time. And so now he's in federal court, and he wants to limit the liability of Bruce Germain to the value of the vessel. It's a recreational vessel. Again, it's probably not worth more than 100,000. Maybe it's worth more like 20,000. I don't know, what the value of the boat was, but it was minuscule compared to the amount of damages that this potential plaintiff might recover if he could show that Germain was even partially negligent by allowing him to take that dive. And we're not going to get into the question of whether it was Germain's fault by diving, but the bottom line is that it was obviously a smart move for the lawyer who did the limitation action to try to do that, because the potential damages against Bruce Germain could be huge. So what happens then? Well, the Northern District of New York, the federal court that sits up in Albany and Syracuse, they recognized that they had to decide before they could hear the limitation proceeding whether there was Admiralty Tort jurisdiction that will allow it to proceed in federal court at all. And now we get into the sort of three-prong analysis, and actually it makes sense to do it like that, which is my hand, but sort of morphed. This one, even though in the opinion it doesn't use the word locus, I'm going to use it, and over here you have nexus. And what do those words mean? Well, if you read the case, the locus part means the location of the incident. So we're not going to talk about it a lot today, but in order to have Admiralty Tort jurisdiction, you have to satisfy both locus and nexus, and this subdivides. We're not going to talk a lot today about locus. I'm going to sum it up in 2 minutes. In order to have Admiralty Tort jurisdiction, the incident must occur on a navigable waterway. What does that mean? It means a waterway that either connects two states or it connects to the open sea. If you have an inland lake, like Lake George, you would never have Admiralty Tort jurisdiction because it doesn't connect two states, it doesn't connect to the ocean. Lake Oneida does because of the Erie Canal system, and I think it's the Erie Canal system that connects it. But the bottom line is, Lake Oneida is a navigable waterway. The catch here is it happened in the very shallow part, not where the commercial traffic is. We'll get to that in a minute. But certainly as to this prong, the locus prong, it did occur in a navigable waterway. Now there's one little thing we're going to get into when I do one of the hypotheticals. If the tort occurs on a navigable waterway, if the causative factor is on the waterway and then somebody gets hurt ashore because of what happened on the waterway, it's still covered under this. And we'll get to that in actually two of the hypotheticals. We're going to do two hypotheticals after this case, and we're going to see how that plays in. But this is kind of a throwaway for today. We're not going to spend a lot of time belaboring this point. We're going to get to these points, because a very interesting thing about this case is it very clearly articulates how this subdivision of the nexus requirement plays out. Nexus means connection. A nexus to something is a connection to something. Nexus in this context, and again, the Judge Katzmann did not use that word, the Latin words he left out. He's not a big fan of using Latin in law, but I use them because they're handy. So the locus has to do with, is it on navigable waters? The nexus is the connection to what? Well, two things. And I guess the best thing to do is take them down here. The first prong, and remember, all three have to be satisfied. In order to have Admiralty Tort jurisdiction, you have to score here, and here, and here. All three. You miss one, no Admiralty Tort jurisdiction. So the first nexus subdivision is the activity. I'm just going to write activity, and not all the other stuff. Is the activity related to a traditional maritime activity? Is it typical of what we consider maritime activity? And then the other prong has to do not with the activity that's going on, but with the incident. So in this case, the activity is non-commercial pleasure vessel use, right? What's the incident? The incident is somebody, the facts of the case, diving and getting injured and all the stuff that resulted from that. So two separate kind of events have to connect to something. What do they have to connect to? Well, I already said the activity has to be related to something that's considered traditionally maritime. And at the end of the day, in this case, in the Second Circuit opinion, the activity of pleasure boat operation satisfied that. Pleasure boats are often involved in maritime cases. It doesn't have to be a commercial operation. So that was easy. This was already given, navigable waterway. So now we get to the incident. Now that's where it gets very interesting, because the incident, it's not a question of whether it's related to maritime activity, it's whether it had the potential to disrupt maritime commerce. Now, in this case, there may have been dispute of the facts, but the bottom line is, it appears, given that this guy was in the water, that he was rescued by water. And the operation of rescue vessels coming in on the waterway certainly had the potential to, and probably did, disrupt other vessels on the waterway. So there was that prong, that the incident had the potential to disrupt maritime commerce, was satisfied in this case. So it really is a 1, 2, 3. The court below, the Northern District of New York, kind of did a little fuzzy logic analysis. Well, it was in the shallow water, navigable waterway, but not really mainstream stuff. And, the activity was, it was pleasure boat, not really commercial stuff. And, I don't think the court below really got into that third prong too well. But the bottom line is they got it wrong. And they said there's no maritime tort jurisdiction. And the Second Circuit reversed, because they very carefully went through each of these 3 considerations. Locus, did it happen on a navigable waterway? Nexus, was the activity connected to some kind of traditional maritime activity? Was it the kind of thing that, courts will hear Admiralty cases in? And yeah, pleasure vessels, that works. And then the last one, which is really the most subtle, is the incident one that had the potential to disrupt maritime commerce. And so the one I'm going to focus on today, to the exclusion of all others, is this prong. The sub-prong of nexus that asks the question of whether or not the incident had the potential to disrupt maritime commerce. Because that is where the interesting arguments can be made for and against, and that's what I'm going to explore in these hypotheticals. In the actual case, it was resolved by a court, so you know what happened. Yes, there was, the locus test was satisfied. There was an incident that occurred. Well, I won't even use the word incident, it gets confusing. The thing happened on a navigable waterway. That's the bottom line. The nexus thing subdivides. Was the activity something that's traditionally maritime? Yes. Pleasure boat operation fits that bill. Doesn't have to be commercial. Now, did the incident have the potential to disrupt maritime commerce? Yes, here, because he was rescued from the water. He dove into the water. Probably somebody, kept him from drowning and kept him on the surface. Hopefully they didn't try to take him out of the water and do more damage to his cervical spine. But bottom line is, he wasn't rescued by any ambulance on land. This thing was in the water. The vessel was in the water. He was in the water, and he was rescued by water. And of course, that has the potential to disrupt maritime commerce. So all 3 of these were satisfied. Now, I want to introduce you to 2 hypotheticals that really focus on this last prong. And we're going to pretty much take it as a given that the first 2 prongs are satisfied, although we'll discuss them a little bit. And we should be able to go through 2 of these hypotheticals in 10 or 15 minutes each. And then we've got a recording that allows you to see exactly how these principles apply in other cases besides Petition of Bruce Germain. The first hypothetical, I will tell you, is based on something that really happened. And the second one, maybe it really happened, I don't know, I made it up, who knows. Sometimes you make up stories and it turns out there's a real life corollary that corresponds to the story you made up. Anyway, let's call this hypothetical A. In hypothetical A, again, we have a petition for limitation of liability. Our question is, does the court have subject matter jurisdiction under Admiralty Tort jurisdiction? So, hypothetical A occurs, this is a roadway, and just down the road, I will mention, there's the ambulance and firehouse, a mile or less away. And now you have a piece of property, and you have a house, and you have a tower, and you have a retaining wall, and for here is the water. And this is on the North Shore of Long Island. And the owners of the property were renovating things. And one of the things they did just before this incident happened was they had a tug and barge come in and replace this retaining wall. The thing was probably 100 years old, crumbling. Well, you need a retaining wall, otherwise your land is going to fall into the water, right? So they ripped that out and they put in a new one. Well, when they ripped it out, they scooped out the soil over in order to get to that retaining wall. And they did this all from the water with a barge and a crane and all that stuff. And then they put all the soil back. And they said, okay, job done, go home. Well, a couple of days later, a week later, whatever, I hope the scale is right here. I think I actually am going to move these houses a little away from the water. So we got the house, and we got the tower, and this is the land, this is the water. What happened, let's make the house taller and the tower taller. So there's a scaffold here, and the worker is on the scaffold, and the scaffold is supported by, I believe it was a ladder, but some kind of solid member that is now holding the scaffold up, and it goes out at an angle like that, and it rests on the soil over here, just inside the retaining wall, right near the edge of the water. What happened? Well, as I said, they had put the soil back in, and they didn't really pack it down. And so the allegation is they negligently failed to make it a solid surface. And so when this ladder was resting on it, and the weight of the worker and his equipment is now pushing down, it gave way. Some of that void space under there that was filled with air collapsed, and the ladder lost its footing and dropped, and he fell maybe 20 feet, and unfortunately didn't land like a cat on his feet. He probably landed on his head, and he became a quadriplegic too. Because if you hit the ground, you know, whether it's diving off a boat and hitting the bottom of the waterway, or if you fall off a ladder and you land wrong, you can, you know, mess up your cervical spine, and you no longer have function, and you can't do that. Reflexes are slow. In fact, you can't do anything because you're basically paralyzed from the neck down. So that's what happened to this plaintiff. So now the question is there, and of course there was a limitation proceeding filed so that the value they can recover from the defendant, this particular defendant that did the marine operation, would be limited to the value of that barge and crane that did the work. So that might be, I don't know, let's say $500,000, but maybe this guy has, you know, $50 million possible award because he's now paralyzed for the rest of his life. Okay. So the question then becomes, can the court, the federal court, hear the limitation action? Is there Admiralty Tort jurisdiction? Well, again, we have the three prongs, right? Locus. Is it on a navigable waterway? Well, yes, it happened on a navigable waterway. This is Cold Spring Harbor, navigable waterway. And yeah, he fell on land, but just to make it quick, if the tort is caused by something that occurs on a navigable waterway and the result happens on land, there's a thing called the Admiralty Extension Act, which is mentioned in the case, which says, yeah, that's covered. So this part is satisfied. So the locus prong is satisfied. Okay? And all these three, the real case and the two hypotheticals are going to have that. The second one is the activity related to traditional maritime activity. Now, I suppose you could argue that this was there just to shore up the land. It wasn't very maritime. But, you know, truth is, a lot of times work on land is done from the water, and that's considered maritime activity. So let's just assume that it's a traditional maritime activity, so that prong is satisfied. So then our only question is the third prong. Is the incident one that has the potential to disrupt maritime commerce? Well, here, I think a very strong argument could be made. Reasonable minds can differ, and the judge has not even heard the argument yet, but it seems to me that there was no potential for the sort of thing that happened in Henry Bruce Germain, right? There's no potential that this guy would have to be rescued by the water. Why? Well, he's here. If this collapses over here, he's not going to fall into the water. He's going to fall straight down. That's how gravity works. and the ambulance is a mile away, and in fact the ambulance that rescued him was the one over here at the Cold Spring Harbor Fire Station, and came in and took him out on a longboard, and he was on land, he was taken to Huntington Hospital by land, and no chance of being in the water. So there was really no, my argument would be, there's no potential to disrupt maritime commerce. So therefore, there would be failure on this prong. The incident has no potential to disrupt maritime commerce, and since you need all three, the argument would be that you have no maritime tort jurisdiction, because even though you have the locus test, navigable waterway, and even if you assume the activity of building the seawall is traditionally maritime, you still have no connection between the incident and any potential to disrupt maritime commerce, because you can argue logically that there's no way he could have landed in the water. All right? So that's hypothetical A, hypo A. Okay. Now it gets interesting, because here's where, in Monday's class, I actually got student participation, and as is often the case, I got some thoughts and ideas that expanded my thinking on the matter. Because you don't really think about how you're going to argue these things until you think about the situation. So hypothetical B, which is not based on any real case I know of, but it's based on facts that I know occur. And actually, one student who's not there, behind you, his laptop is there, I think he mentioned that there was a case where something similar happened, where a barge, its fireworks, had a fire on board. But here we're talking about not that at all. We're talking about, here's the land, and here's, we'll make it Hempstead Harbor, over Long Island, and there's a barge, and the barge is shooting off fireworks, 4th of July. Kind of happens every year out there. I think it's the Dolan family, and they have fireworks, and people over here get to watch the fireworks, and they're on land. Maybe there's some people on boats, but our victim for the day is going to be over here on land. And in my little hypothetical, this barge detonates a firework, and instead of going up here like it should, it goes and lands in the eye socket of somebody who is watching from the shore. Now, before we get into step 3, first of all, this is a navigable waterway, so the nexus is going to be satisfied. It occurred on a navigable waterway. Even though the injury was on land, again, the Admiralty Extension Act, if the forces that begin it occur on a navigable waterway, it's going to be covered. So the nexus prong, location, I'm sorry, not nexus, locus, that would be covered. So now the question is, what about the two nexus-related prongs? Is this an activity that we consider traditionally maritime activity? Now, I suppose you could argue it's not. You know, a barge with fireworks, gee, that's not like a barge transporting cargo, it's not like a commercial vessel, it's not even like a recreational thing. But then again, it is a vessel that's being used for entertainment purposes. So I think for purposes of this hypothetical, we'll concede that launching fireworks from a barge is close enough to traditional maritime activity to satisfy the first prong of the nexus test. But the second prong is not related to the activity, related to the incident. The incident have the potential to disrupt maritime commerce. And here's where it gets interesting with the arguments. In this case, and it's a hypothetical case, it could be argued that it had the potential, because after all, he's near the water. Now let's assume the way it unfolded, he got hit in the eye with a firework and an ambulance came and took him to the hospital. Okay, but he was right near the water, and if I was trying to get Admiralty Tort jurisdiction, would say yes, but he could have ended up in the water and had the potential to disrupt maritime commerce. If you get hit in the eye with something burning, first of all, you're going to run around like crazy, you know, not like the guy who became a quadriplegic and couldn't go anywhere. This guy easily could have ended up in the water. In fact, maybe if you have something in your eye burning, your instinct might be to jump in the water and stop it from burning. But certainly, you're not going to be paralyzed, and you're going to be in a lot of pain, and you might run around, and he's right near the edge of the water, and he could have fallen in, and then there would have been rescue by water that would have required activity on the navigable waterway that could have disrupted maritime activity. So I would say, if I were arguing in favor of Admiralty Tort jurisdiction, I would say there was a potential to disrupt it. So this is different from the prior hypothetical A, because I think it's very hard to show in that one that he could have landed in the water. He fell straight down from the scaffold. Gravity works vertically, and he was paralyzed after that, so he wasn't going to get up and jump in the water and have to be rescued by water. Here, you got a guy hit in the eye with a firework right near the water, and maybe he's going to run around like a chicken with his head cut off and end up in the water, or maybe he's going to make a decision to jump in the water because it's burning and the water looks like a better place than the land because maybe it'll quench the fire. So he could easily have ended up in the water, and then you can have that. So the potential to disrupt maritime commerce is there. So what I'm doing here is taking the test for maritime tort jurisdiction that is very, very well articulated in Petition of Bruce Germain and applying it to these two hypotheticals. And what I'm showing you is how lawyers can use not only facts, but potential inferences to advance their position. And it all comes down to that third prong. You know, you have locus, navigable waterway. Easy yes or no. Traditional maritime activity, you could argue either way, but sometimes the more important one is the incident one that had the potential to disrupt maritime commerce. And here in hypothetical A, where he fell straight down from a scaffold and could not have ended up in the water, I would say no such potential. Here in hypothetical B, where he's hit in the eye with a firework, and he very well could have ended up in the water, whatever the facts were, doesn't matter, he could have ended up in the water, and if he had it with disrupt maritime activity, that would be your argument that, yes, that subprong on nexus is satisfied because there was the potential to disrupt maritime commerce. And believe it or not, all these rather arcane, theoretical, what-if questions actually influence how a judge is going to decide whether there is or is not maritime tort jurisdiction, and if it's a limitation case, it's going to determine whether or not the defendant, who owns the vessel, can avail themselves of the limitation statute and thereby limit their liability to something that's a fraction of what it might be otherwise. These happen with his multi-million-dollar, claimants, have injuries in the multi-million dollars, and the vessels are worth less. So obviously the move is to try to limit the liability to the value of the vessel, and whether or not that can be done then turns on the question of whether there's Admiralty Tort jurisdiction and whether the federal court can exercise a claim. And what I'm telling you is, I think the area where it's going to be mostly litigated and argued is in that subprong of nexus. You have locus, navigable waterway. Nexus has two questions. Is it an activity that relates to something traditionally maritime? And that's usually, you could argue it either way sometimes, but it's usually going to be, I think the judge is going to tend to find, if it's something you did on the water, we'll probably say yes. Fireworks from a barge, building a seawall from the water. Maritime activity is pretty broad. It's not just carrying cargo. Could be recreational vessels, could be jet skis, could be, entertaining from a vessel. Maybe